underreported story segment tonight. Democrats cannot win at the ballot box, so they are resorting to a sneaky tactic to turn left-wing ideology into law. Liberals are renewing their push for the Equal Rights Amendment, a far-left constitutional amendment that dates all the way back to the 1970s. The state of Virginia, now controlled by the Democrats, is expected to ratify the ERA perhaps sometime this week. That means 38 states will have ratified the amendment since the 1970s, which meets the threshold needed for amending the Constitution. But as with many Democrat proposals, the Equal Rights Amendment sounds nice on the surface. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Who doesn't support equal rights? But the truth is this amendment has nothing to do with actual rights and everything to do with government control and the imposition of radical leftist ideology. With us now to break this down, senior policy analyst for the Independent Women's Forum, Inez Felcher. Inez, good to see you.
Always great to be here.
Okay, so first of all, I want you to explain on the basic level here why this amendment, which I read the text, it's one sentence, why this amendment is a wolf in sheep's clothing.
So I think the first thing to understand about this amendment is that women already enjoy full legal equality in the United States. Equality between men and women under the law has never, especially when it comes to things like First Amendment rights, right to worship, right to speak, those have never only been applied to men. And then, of course, when we had the 19th Amendment, women were gained the right to vote under the Constitution. And the Equal Protection Clause of the 14th Amendment also protects women from irrational discrimination on the basis of sex, right? And federal and state law also forbid discrimination on the basis of sex. So women are already fully equal under our law already. So one might ask, why do we need the ERA? And the reason is that the ERA replaces that equality with a very harsh notion of interchangeability or sameness between the sexes that forbids the law from taking into account the very real differences between men and women when they actually matter. And I can give you several kind of terrifying examples, right? So the ERA on its face may not allow any public facility to segregate men and women, for example, with regard to restrooms. So that would apply to all public schools. It would apply to men's and women's sports teams in public universities. Any separation or treating men and women separately would suddenly be constitutionally suspect under the ERA. And there are a lot of other consequences, like I know you and I have talked a lot about the Equality Act on your show. Today, this amendment was originally proposed in 1923 and gained a lot of steam in the 1970s. But the difference between 1972 and today, of course, is that, sadly, in 2020, we are debating what the word sex means. Right? So one of the many consequences of this constitutional amendment would be to constitutionalize something close to the Equality Act. Except instead of carving out exceptions for those who are biologically male, who claim to be female, the way the Equality Act would, it would just say co-ed everything, right? Co-ed sports teams, co-ed bathrooms, even co-ed prisons. These would all be cases that would have to be brought up through the courts and be constitutionally suspect to recognize that it might be actually dangerous to put in a female prisoner in with men.
Right. So, and by the way, the way that this could happen is because of the broad language, because the end of this proposed amendment says, the entire thing says the equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. So the broad language would mean, what is the definition of sex? Does that apply to gender ideology? Does that apply to transgenderism? How exactly is that interpreted by the courts, I suppose, because they would be the ones who would have to interpret it. And at the state level, I mean, you talked to me about this a little bit, but at the state level in New Mexico and in Connecticut specifically, this has been interpreted as requiring the state government funding of abortion out of that one little phrase.
That's right. I mean, this one little phrase could contain multitudes about, sort of leftist social policy and constitutionalize a lot of those radical effects under the guise of just saying men and women are equal. Well, men and women are already equal under the law in the United States, which is why enacting an amendment like this would be so dangerous. And you're right. So in New Mexico and Connecticut, state courts, for both those states have state-level ERAs in their state constitutions. Very, very similar wording. Both of those states have interpreted their ERAs to say that the state version of Medicaid, the health care for low-income citizens, if it covers, for example, the consequences of birth, it must cover abortion under a so-called equality principle, because not doing so would make women unequal. And in fact, proponents of the ERAs, both in the 1970s and in the modern era, they have rejected what's called abortion-neutral language to be added to the amendment, which says this amendment has nothing to do with abortion. It won't touch the legal regime about abortion in the United States one way or the other. So proponents are a little disingenuous on this, and they say, oh, this won't affect abortion, but it has in the states, and they've rejected amendments that would ensure that this doesn't have anything to do with abortion. But at the same time, they'll go out and say this doesn't have anything to do with it.
All right, so they're basically lying about it. So there's no inequality of sex when you're legally speaking under both state and federal law. We already know that. This has been used, this could be used to absolutely obliterate any kind of female-only, like you said, locker room, changing room, bathroom. You know, at schools, especially an 8th grade boy in the same bathroom as a kindergarten-age girl, we could see that. We might not, under an amendment like this, be constitutionally allowed to separate the two. Women might in prison who are incarcerated and have no defense might be put in prisons with men. This is really something, I think, it is a wolf in sheep's clothing, because if you look at it, it sounds fine, equal rights. Hey, everyone wants equal rights for men and women. But when you look at the consequences of this, I appreciate you bringing it to everyone's attention, Inez, because it's something that we should all oppose. Thanks for being here tonight. On that note,